so wise.
Welcome to FCPA Flash, the official podcast of FCPA Professor and moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by the Red Flag Group. The Red Flag Group manages your integrity and risk profile, turning compliance into a competitive advantage. The Red Flag Group assists companies in developing and maintaining efficient and effective corporate governance and compliance programs and has a proven track record in providing integrity due diligence investigations in 194 countries.
Welcome to FCPA Flash. This is Professor Mike Koehler, and in today's episode, it's my pleasure to have a conversation with Homer Moyer. Homer is a member of Miller Chevalier in Washington, D.C., and thank you for joining us, Homer.
Thank you, Professor. It's my pleasure to be here.
Homer is really a dean of the FCPA bar, an FCPA lawyer before there were FCPA lawyers, really. And his background, his perspective, his context on the FCPA and FCPA enforcement is really second to none. And in today's episode, we're really going to focus on sort of where we've been and where we're going in this space. So Homer, as the Foreign Corrupt Practices Act nears its 40th anniversary in a year or two, how would you evaluate FCPA enforcement in the year 2016? In other words, has the Foreign Corrupt Practices Act been successful in your view?
Well, I think if you look back over its history, from a public policy perspective, it can certainly be seen as a great success. This one unilateral U.S. statute has ultimately caused official bribery to become one of the leading concerns of multinational companies operating around the world. It has led to an overlapping set of international anti-corruption conventions, and it's really focused worldwide attention on what is a pervasive global issue that distorts free markets and imposes enormous costs on citizens of countries. So from big picture, from a public policy perspective, I think it could be said to be a remarkable success. Having said that, more aggressive enforcement that we've seen in recent years and multi-jurisdictional enforcement have introduced a host of complications and new issues, ranging from issues with foreign data privacy legislation to the reality of multi-jurisdictional investigations, to occasional tensions between enforcement authorities in different countries, lengthy investigations, sometimes unnecessarily lengthy in my view. And of course, all of these create dilemmas and problems for companies that find themselves subject to investigations. And the cost of these investigations is often greater than necessary, and that can be laid at the feet of both enforcement officials and private counsel.
Yeah, and we'll follow up on the length of investigations and the cost of investigations in a bit here, because I know you've written some comments on those very important topics. One thing I want to tease out perhaps a little bit more is what the definition of success means in this area. You know, from my perspective, so many FCPA conversations use terms, whether it's success, whether it's declination, or whether it's, you know, the term bribery and corruption, that often depends upon, well, what the definition means. And when you really think about it, success can mean a bunch of different things, and you talked about the success of the FCPA from a policy perspective. One of the things that's always interested me concerning the success question is the FCPA really successful when one considers that as we near the fourth decade of the Foreign Corrupt Practices Act, it seems to be that more companies are under scrutiny. There's more enforcement than there was in the third decade. And even in the third decade, there was more companies under scrutiny and more enforcement than there was in the second decade, so on and so forth. Does this strike you as perhaps a bit counterintuitive, or do you have any thoughts on perhaps of success?
Well, to add to your question, I noted that that recently Leslie Caldwell at the Justice Department described FCPA violations worldwide as rampant. So violations have certainly not gone away. But a couple of considerations, it seems to me. It would be quite ambitious to say that the purpose of the FCPA was to bring an end to official bribery, just as it would be a little ambitious to say criminal statutes against murder are not successful if people are still getting murdered. In addition, this is a crime that is by definition one that's committed in secret. So the fact that it is more prominent and more issues are coming to the fore really cuts both ways. Yes, there are a lot of cases, and there are more instances of bribery, obviously, than there are cases. At the same time, if you look at what's happening in terms of enforcement globally, if you're in favor of eliminating official corruption, things are definitely moving in the right direction. Empirically, I don't know that we'd ever know the number of bribes a generation ago as opposed to today. That's not something that we can measure.
Yeah, all excellent points, and indeed part of having effective compliance policies and procedures in place is sometimes causing FCPA issues to bubble to the surface within a company. So even having effective compliance policies and procedures can perhaps lead to more FCPA scrutiny when one might think the exact opposite would be true. And your point with other criminal statutes, of course, is an excellent point as well. And I think listeners need to, take with a grain of salt sometimes when we see policymakers or other commentators saying that the goal is to end corruption. Well, as you note, you can't end any criminal activity necessarily just through a statute, but the goal of this, of course, as you articulated, is to minimize the instances of bribery. And to your point, the FCPA has, I think on many levels been successful in doing that. Now, you have a background and a context and experience in this area that you and the FCPA bar have, and you've seen things evolve here, both good evolution and perhaps some evolutions that aren't so good. What do you see as some of the more significant recent trends in this area, and whether those trends are, a net positive or a net negative or perhaps neutral trends, I guess?
Well, I guess the most obvious trend over time would be that penalties are both higher. They have dramatically increased over the life of this statute. The first large penalty is probably the Lockheed case in the mid-90s at $25 million, which was seen at the time as a very large financial penalty. We have since seen penalties all the way up to $1.6 billion, as you know. So the amount of fines and penalties has increased, and the types of penalties have increased. Not only civil and criminal penalties, but now disgorgement and forfeiture, which has become very important. Also the non-prosecution agreements, the deferred prosecution agreements, which essentially create a probationary period. Monitors, which the government does not view as a penalty, but companies tend to view that as onerous at the very least. So that's one trend. Another trend in the U.S., more recent, is that the emphasis on prosecuting individuals. The Yates memo obviously emphasized this, and in our experience, we are in fact seeing more of those cases. They've been talked about for a while, but I think it's now actually happening. But that in turn will have other consequences, one of which I think will be greater judicial review. The stakes are different for an individual than for a corporation, and individuals are more likely to seek judicial review. And that in turn means more issues will go to courts. And there have been very few FCPA issues subject to judicial review. And so that means, among other things, that if the government overreaches, which it does from time to time, it risks being reversed by a court or by an administrative law judge. Internationally, a pronounced trend of late is increased enforcement in other countries. And most dramatically recently in Latin America, there is at least one major anti-corruption investigation in each of the 4 largest countries in Latin America. And that has been paralleled, I think, by a remarkable growth in public awareness and outrage about official corruptions, which has brought down a number of governments. That's different from a generation ago. There's also, now that there are other countries more involved, more conflicts with data privacy laws in other countries. And finally, a phenomenon that's curious, which is, as you know, that of the largest FCPA cases in terms of penalties, they have predominantly been against non-U.S. corporations. There may be reasons for that and explanations, but it creates a perception issue, I think, which does not go unnoticed abroad.
Regarding the settlement amount you referred to, just for the listeners' benefit, the $1.6 billion was the Siemens enforcement action from several years ago, which the U.S. component was $800 million, and then adding the non-U.S. components gets us to that $1.6 billion figure. It is interesting. It is interesting to see the escalation in the settlement amounts, as you noted. And on one level, this is not so much unique to the FCPA because, 5-6 years ago, one would have never heard of a $1 billion settlement in really any area of law. And over the last couple of years, it seems like you pick up the Wall Street Journal and nearly on a monthly basis, you see, oftentimes some bank, resolving a money laundering or Bank Secrecy Act case for a $1 billion figure. And no doubt, given the passage of time, there will be an FCPA enforcement action that does exceed Siemens and perhaps does get into that $1 billion territory. And to be sure, a lot of people will be talking and writing about that. Do you see any reason or any issues with settlement amounts becoming bigger and bigger for what I no other reason than just because?
Interestingly, I think that from an enforcement point of view, the question can become, for a company like Siemens, which is an immense corporation, what is a meaningful penalty? And I think this is not unrelated to the recent emphasis on prosecuting individuals. that emphasis derives from the view that prosecuting individuals may in fact be a more effective deterrent than prosecuting corporations. And how big a penalty and how painful a penalty even $1.6 billion is for a company the size of Siemens, hard to know. But if individual executives are affected, it's very meaningful at that level.
Yeah, and as you further note in your reply, none of this is occurring necessarily in a vacuum. There's a lot of ripple effects with DOJ policies, a lot of ripple effects with foreign law enforcement investigations. And one that you note is with perhaps an increase in individual enforcement actions, we might see some additional judicial scrutiny in this area, which I think is a very welcome development, given that you can count the number of appellate court decisions in this area on one hand and have a few fingers left over. So it will be interesting to follow and to see what ripple effects perhaps may result from some of these changes in policies, and indeed whether these policies actually result in tangible, observable behavior. One obvious recent event in this space was in early April, the DOJ releasing its so-called FCPA pilot program. Do you see any risk in this new program? This is a program that sort of focused on cooperation and focused on offering credits for voluntary disclosure and cooperation.
Well, it puts great emphasis on voluntary disclosure and seeks to reiterate that companies that make voluntary disclosures will get real and meaningful credit. And of course, voluntary disclosures can make sense for a company in many situations, and they can get benefits. I'm quite satisfied they get real benefits from that. The risk, I think, is there's such emphasis on this that I think everyone should want to avoid voluntary disclosure becoming more important than the merits of the case, the seriousness of the offense, if any. And so it would not make good policy sense, in my view, to be penalizing companies for not making voluntary disclosures. For years, the Justice Department has said that it doesn't want or need to hear about every violation. Minor violations that are dealt with and remediated really don't need to come through the Justice Department. So incentives for cooperation and for voluntary disclosure, that makes some sense, so long as that doesn't get out of balance, I would say, and so long as it doesn't distort judgments about declinations, because if a case doesn't warrant prosecution, it shouldn't be elevated to a prosecutable case because there hasn't been a voluntary disclosure.
Yeah, and as the DOJ itself rightly notes in the pilot program, voluntary disclosure is not necessarily required. You mentioned minor FCPA violations that I guess begs the question of, in the DOJ or SEC's mind, I know this isn't an SEC program, what is a minor violation? As you know, you've seen some enforcement actions of late where some of the allegations are about, golf in the morning and beer drinking in the evening and karaoke bars and cigarettes and flowers have appeared in enforcement actions as well. Do you think enforcement actions that reference those types of issues, clearly they're not the core of the enforcement action, but they're nevertheless mentioned in the enforcement actions, send an effective or perhaps an ineffective message to the corporate community?
Well, I think they typically appear in cases where there's also an old-fashioned bribe. That is to say, you don't see cases really that are built around the small gifts, small violations, and the like. But they are often recited at length in conjunction with a significant bribe. And my sense is that the purpose there is simply to reinforce that there can be violations that are other than conventional bribes. Back in the ABB case, there was a long list of impressive non-cash payments. So I take that as not quite window dressing, but as additional supplementary points as opposed to the core focus of enforcement agencies.
Yeah, 'cause what I think is difficult sometimes for companies is they read the enforcement actions as they are, encouraged to do by the enforcement agencies, and a lot of this evolves down to what I'll call the lowest common denominator, where the company, will perhaps read past the serious allegations of bribery and corruption because that's not what they're doing, but they are doing things in terms of customer travel. They are doing things in terms of customer entertainment, and that's sort of what they latch onto, perhaps, in the enforcement action. It's an interesting, issue to consider. But back to the pilot program, even though in the pilot program the DOJ says, at least formally, that companies are not required to disclose, do you see the pilot program nevertheless as, at least informally, representing sort of a requirement that companies disclose, or risk being penalized for not doing so?
I don't think it quite does that, but it certainly moves in that direction. One thing that's interesting to recall is that in 1977, when the FCPA was adopted, Congress also adopted the anti-boycott law. And the anti-boycott law is a statute that expressly requires companies to report the receipt of a boycott-related request for information or the like. So Congress knows how to require reporting. It did not do so in the FCPA. So I think there's a lesson there, and whereas incentives for cooperation and disclosure in certain circumstances may be entirely appropriate, it would not be appropriate, it seems to me, for those incentives, and the flip side of an incentive is a penalty,
right,
for those incentives to be so strong as to be tantamount to a reporting requirement.
And you talked also in one of your previous responses about the recent trend of disgorgement, including disgorgement in enforcement actions that do not, charge or find anti-bribery violations. What about disgorgement? Do you think that, given what is generally viewed as the purpose of disgorgement, that it is a viable remedy in many of these FCPA enforcement actions, and what are the merits and perhaps issues associated with disgorgement in this context?
Well, I think disgorgement can be an appropriate remedy in certain circumstances, and has been in the law for a long time, an appropriate equitable remedy. At the same time, I think there are risks for abuse and for some confusion. One risk is that disgorgement as an equitable remedy becomes a vehicle for getting around the statute of limitations. If, for example, the SEC does not prosecute a case within the statute of limitations as extended by tolling agreements, but then later seeks disgorgement on the theory that it's an equitable remedy and not subject to the statute of limitations, I think there's a risk of abuse there. Some courts have begun to focus on this, and I think we'll see some case law there. Another interesting wrinkle, quite recent, potentially affecting disgorgement, is that the IRS and the SEC appear to have conflicting definitions of when disgorgement is and is not punitive. On the SEC side, the case law that binds the SEC holds that disgorgement is an equitable remedy and only an equitable remedy. And if the SEC seeks to disgorge more than a company's so-called ill-gotten gains, then it becomes punitive and is not permissible. At the same time, another arm of the government, the IRS, has just issued some guidance on the deductibility of disgorged profits on which companies have already paid taxes. And the IRS has said they're not deductible if they're punitive. They're deductible only if they're compensatory, that is, designed to compensate victims. And so in the IRS eyes, being punitive prevents deductibility, but that's an incompatible and different definition from the SEC definition of punitive and non-punitive. So there's room for a lot of confusion there, I think, between the two agencies and the way they view the issue.
Yeah, that raises another excellent point, that many of the people who pay attention to things that happen in the FCPA space do it obviously with an FCPA focus to it. But so many of the issues in the FCPA space, whether it's this disgorgement issue you're talking about, whether it's statute of limitations, other issues, they're broader issues than just the FCPA. One that sort of comes to mind is the Supreme Court over the last several years has issued various decisions that touched upon bribery and corruption issues, that touched upon jurisdictional issues as to foreign defendants, where if you would take what the Supreme Court says in some of those cases and match that up to what's happening in the FCPA space, there is some incompatibility there. And the issue with the IRS and disgorgement, I think, is another example. Now, in terms of the last topic I'd like to talk about is one you sort of mentioned in your introductory remarks, and is an issue you talked about and had written about previously, and that's the length of FCPA scrutiny, how long FCPA scrutiny tends to last, and indeed the amount of money companies are spending in what I'll call pre-enforcement action, professional fees and expenses. Has some of this become perhaps unnecessary or a life in and of itself, and is greater restraint perhaps needed in some of these areas, or from the DOJ perspective, policy issues need to be rethought, because even bad actors are entitled to have justice that is not delayed?
Yeah, I would think all parties could benefit from a little more discipline with respect to both the length of investigations and the cost of investigations. And part of the problem comes from the agencies themselves. An example is when an agency investigating a particular matter simply shifts its focus to a new area of inquiry or a new country about which it may have no evidence of possible violations, but it's curious about whether there might be other violations somewhere else. And so that can both prolong an investigation and obviously add to its cost. And you can see that in overbroad document requests. You can see it in investigations that are active and then quiet and then reactivated and drift a bit. the so-called industry sweeps really often were focused on questions about whether there is evidence of potential violations in Company B because Company A in the same industry does the same thing. But some of the blame, I think, also rests with the private bar. If counsel advise their clients that nothing but a comprehensive company-wide investigation will satisfy the agencies, we have to turn over all the rocks, that may not make sense, particularly where an investigation shows early on a clear systemic problem that you know then how to remediate. I don't know that you need to pursue that to the ends of the earth. Also, I think the argument that multiple teams of lawyers in different countries in the case of a multi-country investigation, I think the argument that that's an efficient way to investigate is not right. The big drivers of costs for a company are the number of lawyers involved and the amount of time that they spend. And multiple teams that gather information, massive amounts of information that then has to be coordinated and synthesized is often inefficient and very much unnecessarily expensive in my experience, even for a quite large investigation.
Yeah, and this sort of follows on the heels of, I think it was approximately 12 months ago, Ms. Caldwell at the DOJ used the term boiling the ocean. And that concept appears in the recent DOJ pilot program, and DOJ officials have publicly stated in recent months that they're focused on getting these cases resolved sooner. I think I've even seen a 1-year time frame associated with some public comments. Whether that happens in practice, I guess it is a little bit too early to tell and to assess that, but interesting issues. Really from a dollars and cents standpoint, some of the most important issues facing companies in this new era of FCPA enforcement. So thank you very much, Homer, for joining us today.
I should simply add before you sign off that, that the 1-year time limit is something we'd like to see applied retroactively.
Right. Yeah, I can see that. And, thank you again. Your perspective on this area is second to none. And I think as evident through our conversation today, even though there has been some progress made in this area as the FCPA approaches its 40th anniversary, there does remain some disputed and legal policy issues that, are being debated and contemplated in good faith. So thank you for spending the time with us today and providing your insight on these issues.
Michael, thank you very much. My pleasure.